Alright, today we're going to be hearing out Mr. Chang versus the state. I want to make it perfectly clear before we start, whatever ruling happens with the Chang versus the state will happen with the latter of the same submissions. Uh, I'm going to hear out this case of Mr. Chang for the hearing, and if it goes to trial or I make a ruling, or either way, then it'll be the same for all the rest of them.
Perfectly
Statement
understandable, Your
claims.
Honor. According
to the Right of Financial Privacy Act of 1978, 12 U.S.C. Chapter 35, Section 3401, my client, Mr. Chang's constitutional rights under the Fourth Amendment were violated under his private financial records were unlawfully searched and seized without knowledge or consent of Mr. Chang. Mr. Chang became aware of this unlawful search on 5/17/2019 when a criminal case, People vs. Chang Gang, was filed against him using his private financial records as evidence of some unspecified criminal act. My client, Mr. Chang, has been presented with no warrant or subpoena for these bank records. The search and seizure warrant issued to my client related to the People vs. Chang Gang does not contain or reference any subpoena for bank records or other financial documents belonging to Mr. Chang. Either no warrant or subpoena for these records exist, and the records were obtained unlawfully, or law enforcement failed to notify Mr. Chang of any warrant or subpoena for the records. The private financial records of Mr. Chang were listed as People's Exhibit A and People vs. Chang Gang, a criminal action against my client that was dismissed because the prosecutor could not bring forward any specific charges. No indication or cause for the utilization of these private records is given in the court filing, nor have they would be used in the case, nor is there any indication of how and why these records were obtained in the first place. The Civil Rights Act of 1871, 42 U.S. Code Section 1983 entitles my client, Mr. Chang, to file claim for damages resulting to the violations of rights guaranteed him under the Constitution. Mr. Chang seeks damages for the violation of his rights against him, his rights against unlawful search and seizure under the Fourth Amendment. They're asking for relief, Mr. Braun, of $250,000 in punitive damages. Is all this correct?
That is correct.
All right. How we are going to do this is, Mr. Braun, I'm going to let you explain your statutes you're wishing to quote and how you think this case should be heard by the court. And then after you're done explaining all you want to explain under that statute or whatever statutes you want to quote, Mr. Savage can go on his part of how he wants to, of his statutes or however he wants to analyze it or interpret it. And then I will ask both of you questions that I have regarding it. And then I will give y'all an opportunity to ask each other questions, starting with the plaintiff first. And then it will result back to me asking questions yet again. And then I will go to deliberation. Do we understand that?
Yes, Your Honor.
Mr. Braun, go ahead and plead your case to me.
All right, Your Honor. You already referenced the Right to Financial Privacy Act. I will get into that. I will also be citing Section 7480 of the California Code, which is the California Right to Financial Privacy Act, which adds some additional provisions specific to the state of California. I'll get into that a little bit later. I'm just going to go on general terms at this point in time and just lay out my case.
Hold on.
Are you already interrupting me,
Your Honor?
Mr. Savage?
Mr. Savage,
no, I got a question for the judge.
Mr. Savage, what's your question?
He's already filed his paperwork, made his statement of claim. Are we going to allow additional adding to that at this time, which he didn't do initially? He hasn't put in the written...
That's up to me to decide.
Well, I'm just asking the question now.
If that's something you want to bring up, you can bring it up on your side. That's why the plaintiff gets to go first and the defense gets to go second, because you can address those things. So wait for it to be your turn and then you can talk.
Well, that's what I'm asking for clarification for, Your Honor.
Don't ask for any more clarification until it's your turn to speak.
I didn't realize the California Code had to be admitted into evidence. All right,
Continue, Mr. Braun.
All right, Your Honor, ladies and gentlemen of the court, my client, Mr. Chang, has not been served with any subpoena or search warrant regarding his bank records. And at this time, at the time of this hearing, my opponent has not yet added any such evidence into discovery for this case, nor was any evidence added to discovery of the RICO case that was summarily dismissed by Your Honor. So that is fact one. The scope of these records indicate to me, if we must go on assumption, that they were the result of a subpoena. Because if the records were obtained through a warrant, they might look much different, but we'll get into that. Now, if the records were turned over via subpoena, which is a lawful judicial order to persuade another party to commit a legal act, my client was entitled to be notified by law enforcement in advance that these records were being requested from the custodians of that private information. My client was afforded the right to file motion in contest of any subpoena and to be heard in court and obtain a final ruling by a judge. Financial institutions are also required to inform the customer of any requests for information via subpoena before turning over such records. However, due to the uniqueness and function of this city's financial institutions, the responsibility of informing the customer their private records are being requested rests doubly on the requesting party to inform the customer of any subpoena. No such request or notification ever took place. Now, getting back into warrants, if these records were in fact taken with a search and seizure warrant, which is actually the only way my opponent can possibly win the argument here, that would actually be even worse. A warrant is a judicial decree allowing law enforcement to commit an act that would otherwise be criminal or that would otherwise violate a person or business's Fourth Amendment rights. If what we're talking about is a warrant, the warrant is so invalid due to its unlimited scope that we could be talking about criminal charges for officers in a couple minutes here. If those records were taken forcefully, then not only were my client's rights violated, but it's plain and simple theft. Now on to search warrants in specificity. The contents of a search warrant must be specific, with clear targets and criteria backed by probable cause. A warrant for financial records should specify only records within statutory law, which is 30 days, records with clear scope that specify transactions either between specific individuals, large transfers, large deposits, significant transfers between specific individuals, payroll statements, etc. Not everything this year. 1 second, Your Honor. Now, my opponent can argue that there was a search warrant and my client did not need to be made aware or notified of a search of his records. Any search of those records is still illegal, and if need be, will file criminal charges. Because, to be honest with you, just one look at those records speaks for itself as for how far astray of what's required they actually are. Now, coming back to my original point, the records appear to have been subpoenaed. So, in the absence of a subpoena or search warrant, let's just call it a subpoena, and say my client was within his rights to be notified that those records were being requested, and within his rights to file motion and contest that in court. Either way, the ball got dropped here. Hard. I think the best thing for everyone, my client, is for my client, who has not been charged with any crime, to be made whole for this unprecedented blunder by law enforcement, the district attorney's office, and yes, even the judiciary. And then the focus can shift to how we can all move forward and improve and do things properly and get things into court that people want heard. And I assure you that people want this case to be heard, Your Honor. Now, I would like to go briefly into citing some of the case laws and civil codes that are referenced in the filing. As per my previous statements, if a subpoena is issued according to federal code and the California code, specifically specifically Section 7480 of the California Code. That would be, I don't know how to quite say this. I'm going to say paragraph N, subsection N, paragraph 3, subparagraph E. I'll put it that way. That if a subpoena is made, then, essentially they need to be notified. And if there's a reason not to notify them, then that court order does need to be presented to them after the investigation. That is in the California Code. Now, as for federal law, one second, Your Honor. As for federal law, the 12 U.S. Code, Chapter 35, that would fall under 3406 and 3407. I'm going to assume that this is a subpoena here. According to federal law, again, my client is entitled to contest any request for records in court and have a final ruling rendered by a judge before any such private information is turned over to law enforcement. A judge must make that final decision if my client wished to contest that, and that's pretty much the basis of the case here.
All right, is that all you had to say, Mr. Brown?
For the time being, yes.
All right, Mr. Savage, your turn.
Can I get copies of what he was actually quoting for case law? Mr. Brown, can you email me those over so I can actually know what you were stating?
I referenced the codes. Leave
yeah, the codes.
Yep, that's 12 U.S.
Savage,
Code.
every single code he quoted, I have right here, and I just looked at. How come you're not able to do the same?
I had to actually listen to him talk.
So you wasn't listening to him talk?
No, I had to listen to him talk. If I had tried to do that, I wouldn't have been able to hear what he said.
It's quite simple. I mean, most of these codes are 4 numbers. That's real simple to write down. I
fully understand it's simple to write down. But I was just asking him to give it to me. It's much easier, since he has them right there.
Mr. Savage, this is the part where you give your side. Which, go ahead, go with it.
All right. So he's quoted well, let's start off with this. As Mr. Braun is well aware, I was on a leave of absence for about a month or so. So during this time period, ADA O'Sullivan had filed this case without me knowing anything about it. Since this case has been filed, I've actually looked into it and, checked out the files and gone through it. I've never spoken with Miss Sullivan, so she hasn't been able to give me her side of the story. I've been able to talk to the officers involved. So we get some issues here with the filing here, Mr. Braun. First of all, in the defendants, Jackie Snow had no part in this investigation, to my knowledge. So we like to get him removed if this does move to court. We also would like to, motion to dismiss this case here, because we did have a valid warrant substantiated by oral testimony from the CID officers involved, with supplemental information provided to the judiciary body here, and they approved the warrant of the bank records. They were within scope because we asked for specific bank records to look for, as Mr. Braun does know, large sums or large transfers of cash. As for the acts here that he's gone through, we are quoting a federal Privacy Act, which we would not be falling under since we are out of state, actually. If he looks in there in the definitions, let me get this real quick out of my files here. All right. Chapter 35 of the U.S. Code, government authority means any agency or department of the United States or any officer, employee, or agent thereof. The state does not fall under that. We are a state agency. We are not the government of the United States here. Section 3402 requires the government authority to seek either a search warrant, judicial subpoena, or a formal written request that meets Section 3408. What we did here is we did not issue a subpoena, as we do not have access to the bank themselves to issue that subpoena to, so we sought a search warrant from the judiciary body, as we believe that would be the proper way to do it. So that's what we did. And as for Mr. Chang having to be notified under a search warrant guidelines, he would have 90 days of the bank themselves sending him notice. So after the subpoena was issued, the bank turned in the records to who served the warrant. They would have 90 days afterwards to issue the letter to his last known mailing address. And if we wanted to, we could ask for that to be delayed by the courts.
So he's going to go with it being a warrant.
United States versus Miller, that the expectation of privacy of an individual has been already tried by the Supreme Court and the U.S. courts. That if we issue a warrant or a judicial subpoena, that we are entitled to those bank records from the bank. So on those grounds, we do motion to dismiss this financial records. We filed everything correctly. We received the records. We reviewed them.
Your Honor, I object to this.
Moved on from there.
I object to this.
Well, you can't object, Mr. Braun.
I can object because the information he's providing is completely complete nonsense. United States versus Miller is the very court decision that caused the Right to Financial Privacy Act to be enacted.
Mr. Braun, I know what United States versus Miller says, and if it is, all right, if it is quoted incorrectly, I will address that whenever I ask questions. I'm a judge. I know what the statute says. I know what all these statutes says, and you let me handle it as the judge. You will not object during a hearing.
Yes, as I have stated, Mr. Braun, I was extremely busy, as I did try to arrange a meeting prior to this with us. If I'm quoting something incorrectly, that's because I've had very little time to prepare.
Mr. Savage, is this part of your statement, or are you talking to Mr. Braun because you're not supposed to be talking to Mr. Braun now? Well, stop talking to Mr. Braun and go back to your desk unless you have anything else you want to say on your statement.
Nope, that's really it. So I motion to dismiss this.
I got a few questions. Mr. Savage, you said that the federal code says you have 90 days.
No, the bank would have 90 days.
The bank, that's exactly. You said the bank would have 90 days to notify under the federal code. So under 3406, all right, under the federal right to financial privacy of 1978, can you read me, please, Section B?
Let me find the code.
Yo, Judge should be fucking Judge Savage. Just take his name from him. Yo, thanks for all the follows, dudes. Hope you guys are enjoying the show.
Alright, which section do you want?
3406, Section B.
Alright, no later than 90 days after the government authority serves the search warrant, it shall mail to the customer's last known address a copy of search warrant together with following notice. The question here is it. Who stands for it? I think I emailed you about that.
Well, it says pretty clear. The government authority
smash that
says
follow
the
button,
search
guys.
Warrant, it shall mail the customers.
And hey, don't forget about that sub button too,
wrong?
guys.
Is that not any common sense to you?
No, that's why I had emailed you privately about this, because I wasn't 100% sure. I didn't want to incorrectly quote it, because somebody had said it was referring to the bank in a previous
And I
statement.
didn't answer you when you emailed me that because I cannot help you with this, Mr. Savage.
No, I get that, but I was asking for clarification for the courts.
Yo, my buddy, thanks for that sub, dude. Appreciate you, man. Some love in the chat. Oh, Spaz coming in
So,
with the
Mr.
5
Braun,
gifted subs.
if the
Thank
federal
you.
code under the Financial Privacy Act of 1978 says that the government has up to 90 days under Section Code B to send notification of any financial records being such, why do you think you have a case?
Well, there's lots of reasons. First, I do want to specify for Mr. Savage that the California Right to Financial Privacy Act does uphold the federal guidelines for the most part and add some
Mr. Brown,
additional
I asked
provisions.
you a question. I did not ask you to address Mr. Savage. Now, please answer my question.
Well, I mean, it's plain and simple. The records which were obtained are broad in scope and reach further back than statute allows. There is no specific large transactions shown in these records. There's most of these records, if you look at them, half of them for half of these people, we're talking about Mr. Chang for the purposes of this hearing, but you are including everyone here. A lot of these transactions, they are fines from being put in jail. You have payroll payments, you have small transfers, and you have everything all the way back to at least March 1st. March 1st. How long ago is that? Is that 30 days ago? From May 17th? Or from even April 25th, which appears to be the date in which these were obtained, as far as I can see from these records. The scope is completely laughable. There's no specific nature to the records that have been obtained. These records, if there was a warrant, that warrant is completely nonsense and invalid, and the scope is laughable. There is a case here.
That's not, Mr. Braun, in your case filing, that's not what you were arguing. You were arguing that they had been notified that the records were such, not that they were unlawfully searched in the first place. Your case file says that they were not notified that they were searched. Now, I gave you Section B under the statute that you gave in your case filing that says that they have 90 days to notify. Now, tell me why you still have a case.
Well, Your Honor, no one provided a warrant and no one provided a subpoena. Not in the RICO case, not in this case. So I don't know if we're dealing with a subpoena, and I don't know if we're dealing with a warrant, because no one has shown us anything. Why are they not showing us anything?
They have 90 days to show you. Says here they don't have to show you yet. Says here they have 90 days. So tell me again, why do you have a case?
Let me take a look at the case law again.
Feel free. I'll put the court in recess for 5 minutes.
Where does it say 90 days? All right, Your Honor, could you give me the specific section again?
Section B, under the Financial Privacy Act.
Section B. All right, Section B.
Yep. B is in Bob, Billy.
Yeah. No, I got that, but I'm not seeing a Section B.
You're not seeing a Section B under the statute that you filed your case on.
Not on what I'm looking at. Is it subsection B? Is it Section B? Do you have a number? Something easier to look?
Wait, what are we looking at?
3406 under the Financial Privacy Act of 1978, 3406, Section B.
All right, thank you. Okay, I'll go. Well, whatever. Well, we're gonna lose. We're gonna lose, but that's okay. But let's take a look. No, I don't want to lose any of these cases.
Are
Because
you,
this
are
whole
you good,
thing is.
Mr. Braun?
Yes, I was just waiting for you.
I've been here the whole time. Wait, I'm waiting. I'm good.
Okay.
You're the point of the recess.
Yeah, we're out of recess. Dude. Come on.
All right. Well, that's the federal code. The California code is 10 days.
Absolutely.
Where is 10 days quartered in California code?
Mr. Savage, this isn't your turn to talk. I'm the one asking questions. You're not asking questions. Your comment will be stricken from the record. Keep it to yourself. When I ask you something, then we'll get to you. Mr. Brown, the California Code does say 10 days. How come in your case file you quoted federal law instead of state law when it comes to the statutes?
Well, I started with federal law and I moved on from there. It's a very large undertaking. I've, been working on this. So, with the original filing, I cited the federal law. And California law largely, as I said, upholds the federal ruling, but adds additional provisions that actually increase the protections of the citizens in the state of California. The state of California stands behind the Right to Financial Privacy Act, and any amendments they make at the state level only increase and enhance the protections of the citizens of California.
And Mr. Braun, the Federal Privacy Act, the one you had in your case file, which sort of law enforcement does that cover?
Federal.
Is our police department federal?
No, which is why I've moved on to the California code, which specifies state actors as opposed to federal agents.
So you blew your load too early.
Well, I mean, again, the California code does uphold much of what is laid out more clearly in the federal case, in the federal law. So it was valuable. California code mainly adds provisions, and it's a lot easier to understand the general language of the federal law than it is the California law. So it was a good place to start, Your Honor.
All right. Mr. Savage, you quoted me the Miller case. Give me the context of that case, verbatim, as it says in the relevance to this.
Sorry, repeat that.
The Miller case that you filed, that you talked about, under the statute of the federal, you told me things that were inside of that Miller case.
No,
Tell me the context.
I quoted
what?
I quoted the United States versus Miller 425 of the U.S. 435, 1976. So, what was held by the Supreme Court here in this ruling was respondent possessed no Fourth Amendment interest in the bank records that could be vindicated by a challenge to the subpoenas, and the district court, therefore, did not err in denying the motion to suppress. What we did here is we got a warrant. This is clearly stating that the lower courts did not err in denying the motion to suppress for subpoena. So what we did was we applied for a search warrant. That's why I quoted U.S. Versus Miller. So we went beyond what what Mr. Braun alleged that we did, and we went to the right, system to do it properly.
So, Mr. Savage, you're giving me case law that built against, in other words, the feds. Am I right?
I believe he was trying to suppress microfilm and bank records that were taken from a bank.
And who was after him? Who was trying to prosecute him?
Yeah, Judges wants me to fucking be on top of shit. I feel like we're gonna move forward with this. I think we're gonna have to keep our shit
West
together.
has something for you.
I'm sorry, I didn't know Miss West was on the docket.
Oh, Miss West is the ADA. Once you get one, you get us all, unfortunately.
Well, that's not what I was asked. I was asked to have you here, not Miss West.
Well, unfortunately,
so if Miss West
when you sue the
is your
state, you get all of
co-counsel,
us, and that's been established by Chief Judge
Mr.
LaBar
Savage,
over there.
if Miss West has something for you, for me, she can tell you, and then you can tell me it. But I'm talking to you. You were on the docket.
Unfortunately for you, Your Honor, that's not what's been ruled here previously in the courts. So Miss West can speak.
I don't care what has been ruled here.
Doesn't matter
This
what you
is what
care.
I'm saying now.
It's what actually
Mr.
is
Savage,
true, and it's been ruled before.
Mr.
And
Savage,
if you want to challenge that, you would
Mr.
have.
Savage,
you would be,
I will hold you in contempt if you keep it up.
For what?
Because you're challenging a judge, and it's not your place to. I said she cannot speak. She was not on the docket. If she wishes to tell you something, and you wish to relay it to me, then so be it. But you're not going to step out of line.
Get your popcorn, chat.
What we're saying is,
get your popcorn, chat.
I have a question right here. We've clearly established this through multiple
Mr. Savage, I'm asking you questions. You're not asking me questions.
Well, no, you are overstepping your bounds on the judiciary.
I'm not.
But
I'm
yes,
not,
you are,
Mr.
because
Savage.
this has already been clearly established by Chief
Silence,
Judge
Mr.
LaBar
Savage.
and
Just stop talking.
Judge Artson
Stop talking.
beforehand.
I don't care what Chief LaBar or Judge
Well,
Artson
neither
said.
care.
I'm not Chief LaBar and I'm not Judge Artson. Now, if you wish to have her say something, she can relay it to you and you can tell me.
All right, we want a sidebar then.
You can have a sidebar, but not we.
I'll go for a recess, possibly, so we can talk for a little bit.
Mr. Bond, you need to be here since you need to hear everything he says.
How are you, Mr. Brown?
Fine.
As you
Mr.
know,
Savage,
the
why'd
last
you
time we
do a
went to
sidebar?
court. Well, no, this has clearly been established beforehand. That
I don't
if you
care.
do challenge the state, it's not if you don't care. This has already been argued 17 different times.
I don't care.
Then we would like a recess.
Denied.
So I can go over what she's trying to tell me.
Denied.
What do you mean deny?
Oh, that's great.
Mr. Savage, are you telling me that she has something so important to you to say that she can't tell you at this minute and you need a recess to evaluate it?
I don't know what she's quoting, and she's got a lot of stuff for me to look at. That's why I was going to say she's capable of
Mr.
doing
Savage,
it herself.
you got 5 minutes. And this is
All
me
right,
being
no problem.
very, very nice. 5 minutes.
Denied. Denied. Denied.
Can we speak to you during this recess, Chief Judge?
For what?
We've already clearly established that if you get one DA,
Think you get the
us
whole
all.
village involved in this?
I mean, it's
We've established this in
probably
multiple
not in your
cases.
best interest. Okay, and
So would you like
you're
to
in
go
the
right
middle
in, your
of a
judge
court
there?
hearing. I'm not going to stand here.
I'm
and
on a
correct the
recess.
Judge during a hearing.
You're on a recess
okay?
or not?
You understand
Judge
what I'm
LaBar
saying?
is listed as a witness in the matter at bar, and I find it
Exactly.
incredibly
Sir, it's a private conversation.
inappropriate.
Stay out of here.
I don't
find
care
it
if it's private or
incredibly
not. You're in a court of
inappropriate,
law.
too.
There's nothing private in here, Mr. Savage.
It's at
And you're
recess.
tampering with a witness right
It's
now.
at recess. I am not tampering a witness.
Mr. Savage,
literally
go
asking a
talk to
question
Miss
for
West like you
judiciary
wanted to
oversight from the
during the
Chief Judge.
recess and find out what you want to know.
Exactly. Nothing to say to that.
I love how they got the whole fucking town working together on this against just little old me.
Mr. Savage, I believe I was asking you, the question was, now that we're back in session, court's back in session, the Miller case that you were talking about under the Federal Financial Privacy Act,
Yo, Tad, thanks for the 100
was
biddies.
it looked into by state or federal employees?
I believe it was federal employees, but I'm not 100% sure. I was reviewing it before the start of court today. Wait, can
Right.
you hear
So
me?
I do hear you. So if the statute was based off of federal law and we fall under state law, and
I wonder why this
how would that be
shit
relevant at
federal-
all at this
Well,
point?
you
hasn't
have
updated
supremacy
yet.
clause. Federal overrules state.
It does, except when it comes to financial records. Every state
And
has
why
their
is-
own financial records, unless you're
All right,
dealing with
explain-
the federal.
Sorry, what was that?
Unless you're dealing with a body, a department
Colby, thanks for the
in the
100 biddies.
federal bureau, then any other law enforcement agency you go to
Paying it forward?
is gonna
Yo, thanks
be
a lot, dude.
state statutes. That Privacy Act
Stream
is
labels has
only
got to
gonna
catch up
fall
with the sub
under
count.
any type of federal investigations, any type of government body.
We're up to
And you yourself, I
394.
believe, defined government body, did you not?
No, I did. So that's, I'm in agreement with that. But also, when I was reviewing USA versus Miller, there was California.
Oh
things
shit,
quoted.
Sundays gifted
I just never had
5.
time to
399
properly review them.
dudes.
So I didn't want to start quoting the California one, not reviewing them. But Miller would lead into it at some point to the
So
way the
that's
syllabus
why
was
I'm
laid out.
asking you if it was federal and if there's any type of state statute in that
Oh,
whatsoever.
thank you so much for all the
how
gifted
is it
subs,
relevant?
guys.
Oh yeah,
You're
hold on.
at
give me a second.
$3.99
I
right
can't hear
now.
when I'm pulling up the documents and I'm switching over.
Oh shit. 404. Not found. Dude, Flippy, thank you very much for those 5 gifted subs.
All right,
All right, I'm gonna get back to the
third party
case.
does not violate
Sundays.
defendant's right, even
Flippy,
if a criminal
thank you
prosecution
guys
is
for the gifted
contemplated at the
subs,
time
dude.
subpoena is
Poggers.
issued as California Bank Association versus Schultz. So,
Can you
which
repeat
is,
that a
again,
little
we went
slower?
for a warrant. Should I just email it to you?
No, I want you to quote it to me just a little
All right.
slower.
Issuance of a subpoena to a third party does not violate a defendant's rights, even if a criminal prosecution is contemplated at the time the subpoena is issued. California Bank Association versus Schultz, 416 U.S. 21, 416 U.S. 53. And then there's a bunch of other stuff.
So I have to ask you.
I never reviewed it.
Was this a subpoena or a warrant?
Again, it's a warrant, which is classified higher because that's what we went for. Because
So
it's not a
if what
subpoena.
you quote me says if it's for a subpoena, then why is it relevant?
Because originally he's quoting here that we used a subpoena. So if we did use a subpoena, we would be lawfully allowed to do it.
But
we
you
went for a
know,
warrant.
since you're the DA, you know that it wasn't a subpoena. So why are you telling me things that are irrelevant?
Because that's his claim. And that's what I'm telling him, that his claim is wrong.
So why didn't you open up with maybe it's a warrant and not a subpoena?
I did that.
Did you?
Yes, I said I got a warrant. And he explained how he came to the warrant and how he went through the process of getting the warrant in the original opening. But then I went into this, so he understands that I still had rights under a subpoena. So he doesn't
At
keep
this
filing
time-
this, and we're here 80 friggin' times.
At this time, I'm going to allow each other to question one another. Keep in mind that this is a hearing, and this is just question concerning statute law, and it's not a witness testimony, so no one's going to be under oath. Mr. Brown, you'll be allowed to ask Mr. Savage however many questions you feel, and once you're finished, Mr. Savage, you'll be able to ask questions back.
Can I have Braun on the
simply-
oath?
No, this isn't a witness testimony. You're arguing statutes of the law. If someone asks someone a question, answer the question. Don't start talking about other things. You'll have your time for that. Mr. Brown, go ahead.
All right, Mr. Savage, where is this warrant?
In a filing cabinet.
Did you not find it prudent to maybe bring it with you to court today?
It's not what I was asked to do.
Okay, but you did not feel that this might help your case to produce this warrant in court? Show how
Mr. Brown,
wonderful
don't lead
it
your
is?
questions. Brown, don't lead your questions.
Sorry, can you ask, or can you, I guess, reword that?
Well, Your Honor, with all due respect, you did say this isn't witness testimony.
It isn't witness testimony, but I'm not going to allow you to lead your questions. I want straight answers and straight questions.
All right. Why did you not bring this warrant with you today?
No real reason. Didn't really think about it, to be honest with you.
Okay. Okay. Let me think of another question for you. Mr. Savage, are you aware that United States v. Miller, the case law that you cited, was the inspiration for the actual act that you're arguing against?
Before this?
Yes, United States v. Miller was in 1976. We were talking about the 1978 Right to Financial Privacy Act.
1978.
That's correct.
I had an idea that this was the cause of it, but like I said before, and I'll tell you this: the truth is, I'm a very busy man, and by the time I get to go down all these rabbit holes, it's usually about 5 minutes before we step in there, and that's why I had reached out to you, Mr. Braun, and asked for a meeting, so we could actually try to settle this out of court. But again, you refused to cooperate, and schedule the meeting.
I told you my availability, and you had some choice words for me, Mr. Savage.
Mr.
Not
Bond,
my
is that
problem.
a question or a statement?
I was responding to what he said. But
Was that
moving
a question or
on.
a statement?
Moving on. If this is a warrant, Mr. Savage, are you aware that the warrant is completely invalid according to statute?
What do you mean? How is it invalid?
Because the records which were obtained fall outside of the scope of the statute of this city, which is 30 days. Records dating back to March 1st. It's longer than 30 days. No scope requirements, no specific records taken, no large transfers, as you specified in your statement.
Okay. I see where you're going with. Let's see how I answer this. Okay, I got the date, and the answer is I don't really have a comment at this time.
No comment. That's your answer about the scope and nature of this warrant. There's no comment.
No. I think we were within the scope of what she applied for. ADA O'Sullivan. The scope would have been the financial records of Mr. Pistone, the PDM records, and these individuals.
Okay, so the records, all of them, just the whole records, everything.
What do you mean? What is the question here?
The question is, what was the criteria? What were these scope-defining requirements?
That question.
Well, you seem to be speaking on her behalf about the nature of this warrant that you haven't brought with you. So I ask again. I ask you again, what is valid about this warrant to begin with? That is what we're here about.
I'm gonna stop you right there. None of these questions are relevant to this case right here. They might be relevant to your future cases, but they're not relevant to these cases. I need you to ask questions relevant to the case that we're dealing with at the moment.
I don't see how it's not relevant. My client's rights were violated.
Tell me how it is.
And the validity of that warrant has everything to do with my client's rights being violated.
Your argument, Mr. Braun, is that the search warrant, the information gained off of it can't be used after 30 days. I agree with you, but it isn't that it can't be searched in the first place because it was past 30 days ago. Like, I don't get what you're saying.
What I'm saying is that the records that have been admitted into evidence off of this search warrant span further back than 30 days. I'm not saying that the warrant is outside of 30 days. I'm saying that the scope of the warrant is outside of 30 days. It is, in fact, closer to 90 days.
And how is that relevant at all to what you filed in your case file?
Because his argument is that because they had a warrant, that my case has no merit, but the warrant itself is invalid. So my client's rights were violated.
Mr. Braun, if a warrant where the information there is invalid because it's past 30 days is filed for court. If it's invalid, it's dismissed from the record and it's not used in court. What does that have to do with what you're suing for?
Because the records were nonetheless taken. And Your Honor, again, I
They
had
were
no way
taken
of
within
knowing.
the scope of the
I had
file.
no way of knowing going into this whether it was a subpoena or a warrant, which is why I presented the dual narratives. If it's a subpoena, then they should have been notified. If it's a warrant, then they didn't have to be notified, but the warrant is bogus. So the rights were violated just the same. Either it was basically theft, or they just should have been notified. One is better for some people than the other. One is better for some people than the other. But the
You're
end result
arguing
is the
that
same.
They wasn't notified. You're arguing that they wasn't notified.
If it
So
was a
keep the
subpoena,
question.
absolutely, they weren't notified. But even if it was
It's
a
a
warrant, their rights were still violated. Because the warrant
Right.
is unjust and unlawful. So I want to see this warrant so that we can start focusing on the fact that it's a warrant. Now that we know it's a warrant, great. We can amend the case. We can reshape the case, but there's still a case here. You bet there's still a case here.
All right, Mr. Brown, you got any more questions you want to ask Mr. Savage? Keep it in the scope of the relevancy. I don't want to hear anything about the invalid, the warrant being invalid.
No, I got nothing
I do
further
not
for this
find that
man.
relevant. Savage, you have any more questions?
I'm fine at this time.
All right, we're gonna go back to the last portion, besides the closing, where I have a few more questions.
Wait, why do we have a closing? This is just oral hearings.
Oh yeah, I want to hear a closing.
Wait, we.
I want to hear everybody give a final say based on what they've heard today. Mr. Brown said he learned a few more things today. Mr. Savage, you said you learned a few things today. I want to hear what you have to
When
say
did I say I
about
learned
it.
a few things?
Apparently, you learned a few things because a lot of things you didn't know. Now, Mr. Brown,
Yes, Your Honor.
you're suing for punitive damage. Is that correct?
That is correct, Your Honor.
What is punitive damage?
You're asking me to define punitive damages?
I am.
Okay. I'm just gonna Google to be a fucking shitlord. Okay, do you want me to go by United States law here, or, do you want me to read from something?
United States law, absolutely.
Okay. Well, they are, as they state in the title, they are punishment when the defendant's behavior is found to be especially harmful.
Is that in the case of a tort case? Because this would be a tort case, correct?
That is just in general in a tort liability. They would only apply if the plaintiff can prove the defendant engaged in intentional tort or engaged in wanton and willful misconduct.
Would you agree this is a tort liability case?
Well, I would argue that. I could argue that. There was a willful
You could.
disregard of city and state statute here with this warrant.
Well, falling under tort liability, on the U.S. Code 3417 Civil Penalties, it says, and I quote, such punitive damages...
That was a long
Oh
reach.
my god.
Long read.
Oh shit.
Oh.
Is everyone alright?
I want that man detained and arrested.
It's not gonna happen, Mr. Savage. You know what happened.
I gotta go to the hospital.
No, QWERTY's back.
Oh,
Thank
yeah?
you for the
I got
fucking
some
Yeah.
bandages. You think that might help you?
No. I'm probably gonna fall.
Dude,
Alright.
thanks for the sub query.
I'm gonna put the
Your
court-
Honor,
I'm gonna
we
put
could
the court
recess. We'll
into
take him
recess.
down to the.
I'll
Yeah,
put
we'll
the
take him
court
down
into
to the
recess.
hospital. Thank you, Your Honor.
Mr. Brown, please refrain from being savage
There
to
you
Mr. Savage.
Yes, Your Honor.
Your Honor, if I may approach the stand.
Absolutely.
I regret to inform you that I believe Mr. Savage has actually been admitted for a 3-day hold in the intensive care unit due to a brain hemorrhage.
Oh my god, are you kidding?
Uh-huh.
Yes, Mr. Braun, I am. He's absolutely
Sure.
fine.
Alright, good.
I sure hope so. I gotta say, Detective, that was a good one. You about had me heated. Mr. Brown. I'm gonna put this
So
court
where
back
were
in
we since I was
recess.
so viciously attacked by Mr. Braun?
Punitive
I
damages.
think we know.
Flippy coming
I
in
think
with
we
another
know what
10
happened
subs.
there,
Dude,
Mr.
thank you
Savage.
so
It'll be
much.
quite all right. So U.S. Code, Section 3417, civil
Flippy,
penalties,
thank you so much,
which
dude.
is federal, states, and state
That's
does
about to
take
break
this this avenue with the same thing when it comes to tort law. Such punitive damages as the court may allow, where the violation is found to be willful or intentional. So you agree this is a tort case because it's tort liability, correct?
I'm going to withhold comment on that, Your Honor. I'm not going to say whether or not this is a tort case. This is a 1983 civil rights case, and punitive damages are due the plaintiff if willful, intentional harm has been done to my client or with willful disregard to my client's rights. Now again, in terms of statute, the warrant has plenty of issues, and ignorance is no excuse for violating the law or ignoring statute in carrying out a search warrant. So I would argue that under the guidelines of a 1983 case for Fourth Amendment violations, that that the punitive damages are justified in the amazing amount of blundering that has been done about this entire case, but specifically this warrant for these records.
So is this a civil liability case? Do you feel the state is liable for these things that happened?
Absolutely.
Civil case, so it is tort.
Mr. Savage, I'm not speaking to you.
Flippy Link, thank you so much for those 20 gifted subs,
So if
man.
this is a
You're gonna
civil
break me.
liability case,
You're gonna
it
break me.
is a tort liability case. And tort clearly states that they would be willful or intentional. Now, Mr. Bryan, do you feel that the police intentionally didn't notify Mr. Chang of that warrant on his financials, or do you think they just didn't know any better that they had to?
What about callous and reckless disregard, Your Honor? Does not necessarily
Callous and
need
reckless
to be
disregard.
intentional.
Well, you're falling back callous and disregard. It's hard to be callous and hard to disregard on something that you had no clue it existed. You yourself, Mr. Bryan, just recently just learned about the whole California state financial privacy, and you expect the officers to know about it and try to claim that they willfully or intentionally avoided it?
Well, they willfully disregarded the statute law of this city in carrying out this warrant. What about that?
Mr. Bryan, you claimed that it's 10 days before the search warrant for the financials is done that the party has to be notified under California law, correct?
Correct.
What statute is that?
That was, fucking goddamn it, Judd. Section 7480, subsection N, paragraph 3, subparagraph E.
Can you read that?
Where a court has made an order pursuant to this paragraph to withhold notification to the customer under this paragraph, the peace officer or law enforcement agency who obtained the financial information shall notify the customer by delivering a copy of the ex parte order to the customer within 10 days of the termination of the investigation.
Mr. Savage, I believe you asked out of
Yo,
line
Flippy,
earlier
thanks for that
which statute that
$50
was. Do you feel satisfied
donation
now?
and all the fucking gifted subs,
Yeah,
dude.
could you email a copy? There's something going on in my head right now that's I heard what it was, and I have an idea where it is.
Mr.
now.
Braun, is there any way you
Send me a
could
copy later.
email Mr. Savage that statute?
Yeah.
I do not need a copy of it. I already know it.
I heard what it was about. He's saying 10 days after the criminal investigation is over. That's the key line in that.
That's the key line. I don't know, man. I don't know if we're gonna win it. Did I miss, like, a big donation earlier or something? I was at 500. Now we're at 620. What happened? What did I miss? $500 plus 50 is $550. Where were we at 620? I must have missed something. We'll get to that. Hang on. Donation. Flippy, okay. An
Sorry, are you waiting on me?
$80 donation.
I'm
Wibbs
waiting for
donated
Mr. Braun to give
20.
you that email. And then
No,
you
I
can
have it,
go
I
right
have
on
it.
You got it.
It's
All right.
Dude,
completely
I
different
missed
than
a
the
couple.
California
Wibbs
Act I was
14,
reading.
thanks for the $20.
It's much easier to read this one
Anonymous.
than the one I was reading.
Another 25. Flippy
Is
with
it
50
to
and
your
80.
satisfaction?
Dude, Flippy, thank you so
I
much.
would need more time to review. Unfortunately, there's things going on in my head.
Well, fortunately for Mr. Braun, I have read it, and I do understand it, and I do already know it.
Dude,
and
thank you guys for all the
and
love.
it is to my satisfaction. Mr. Braun, in the National Byproducts Inc. vs. Sexy House Mover Company, the Arkansas Supreme Court found that awarding punitive damages requires evidence that the defendant proceeded intentionally with an unlawful action after knowing that the act was going to be unlawful. You agree that that's the case here?
Yes, 100%, because the search warrant is garbage, Your Honor, with all due respect. Completely
So you
ignores
agree that it has to
statute
be-
law in this
So
city.
you agree that it has to be intentional before it can be imputative? That's what I
Yes.
just asked.
30 days has been the established statute for evidence to be admitted in a criminal investigation. The
Mr. Braun,
case
we've made
that
perfectly
this
clear
warrant is
here
pursuant
that
to is based on, quote, a few months of investigation. That is why we are here,
It-
Your Honor.
Mr. Brown, we made it perfectly clear that the 30 days it would be irrelevant. Now, whether the search warrant
How,
was
Your Honor,
valid
how
or
is
not
the 30
valid,
days irrelevant?
It's irrelevant because you're not questioning in this case whether the search warrant is valid or invalid. You're questioning in your case file whether they were notified or not during the right amount of time. If you wanted to file a case questioning whether a warrant was valid or invalid, feel free to do so. But that's not what you did here. So yes, it's irrelevant.
All right,
I don't
go.
have any more other questions. Mr. Bryan, do you have anything you want to say in your closing?
Yes, I do. Your Honor, ladies and gentlemen of the court, this is the most catastrophic screw-up in the history of this city. Now, we can split hairs, and we can nitpick, and we can judge things which are being filed based on critical information being missing, things not being provided in court filings, criminal cases. We can nitpick away until there's nothing left, or we can actually man up and do something about this and come to a resolution that allows us, again, to move forward constructively and progress towards doing things properly and having the police, hello CID, able to bring forward their cases properly in court that they want to see heard. You want to toss this case out? Fine. It's going to go a long way to ensuring the same old stuff happening over and over again, but I'll tell you right now, there'll be a lot less lawyers in this town. Maybe some of you want that. Maybe that's a good thing. Who knows? But I rest.
Mr. Savage, you have a closing?
Thinking here. Alright. Mr. Braun filed a case alleging that we violated the Fourth Amendment here, saying the officers didn't have any reason to search financial documents related to the individuals named and the enterprise. We followed procedure. We filed for a search warrant. It was approved. And that's how we obtained the financial documents. Now, as for the case being kicked back by the courts because it was improperly filed by Ms. Sullivan.
I don't want to file like 20
I'm still
cases
reviewing
though.
the documents, so the investigation is still
Come
ongoing.
here just to like, oh, well,
I have to
you
line
did it
up
wrong because you didn't know. Now you
allegations
got
in
to
it
do it
to
all
see
over
what fits
again.
Statutes here in the city.
It's fucking AIDS, dude.
Which is what I'm still piecing together. I do have some preliminary findings, and I tried to reach to Mr. Braun to sit down and talk to him. He basically refused because he was quote-unquote busy at the time.
Your Honor, he's
but
committing
I had-
perjury here. I did not refuse.
Mr. Braun, he's not under oath.
We're both under oath. I thought we were.
Did I swear
No.
you in? When did I
He's-
swear you in?
He said we weren't on the oath at all.
Alright, well, either way, he's lying,
for us to be
and I
put on
take
the oath.
affront to that. Correct your statement, Mr.
No, that's
Savage.
actually what you said.
Mr. Braun, it's the closing statement.
I said I
It's
refuse.
a
I
hearing.
said I refuse, Mr. Savage.
Mr. Braun,
Really?
Mr. Braun, I
Then
will
maybe I
hold you in
misheard
contempt. Both of you. Stop and shut up. It's a closing statement. I know what you said, Mr. Braun. That's for me to judge. Mr. Savage, continue with your closing statement. Mr. Braun, do not interrupt anymore.
Yes, Your Honor.
So the courts are completely understand here is that I wasn't involved in this case at all. From the beginning of it, from any of the search warrants or anything. I've literally been reviewing it since Saturday of this week, of the previous week. This financial case was filed. I've had to make room to deal with it and go through the statutes just as yourself. I've had questions over it. And as the document Mr. Braun had given me, this is not what I was reading towards California. I seem to have been in something else. So at this point, what we are stating here is we wish for this case to be dismissed because we don't think we violated any of their rights as we follow judicial guidelines to obtain the warrants properly. And Mr. Braun, through his own admission, has not applied to or even spoken to me about reviewing these issues with the warrants. He didn't even know about them because he, again, before we came to court today, did not want to talk. I reached out to him multiple times. I told him I had preliminary things. We could discuss it. Get your clients together. We'll see if we can find an amicable solution to everything. And that's where we are today.
All right.
And yes, this is a
believe it.
tort case since he filed a civil case.
All right. I believe that's everything. I'm going to go back in
Thank
my
you.
office. I'm going to deliberate on this. I'm going to go ahead and give you a heads up. This is going to take me quite a while. So please bear with me. I'm going to put the court into recess.
Judge Coyote,
Yes.
I need to get out of here as soon as possible. I got unfortunately get things in my head.
You do not have to be here for the verdict.
All right, excellent. I appreciate it. Just want to let you know.
I can always let you know.
I did not refuse to meet with you. You told me and demanded and basically just said, meet me right now or else. And I was busy.
I asked you if you come to the
Boo-hoo.
office. You decided to sit and stop at the fucking courthouse steps, a grandstand like you always do. You want to keep that shit up? Go ahead.
Yeah,
Sometimes
I mean,
stuff has to get done.
calling
you gotta show a
people,
little bit of respect.
calling
Not
people
everything's
cunts.
about you,
Oh,
Ron.
calling someone a cunt is respect now.
Because you
I
can
see.
be one.
Yeah, so calling me a cunt is a great way to get me to come and meet with you right now when I got other things to do.
No, it's
when I'm in the middle of
definitely
something.
meant to
That's
be
refusing.
a motivational.
You know, when I want to meet with
so you
someone,
can figure
Mr.
out and do
Savage, I
something.
say, hey, what's a good time for you to meet? I would like to talk to you. Not, get in here
Yeah, you
now,
asked that 2
right
days
now.
prior.
Everything's right now. You think the world revolves
No, I
around
asked
you.
you to come to the. If you had time to come to the DZ office.
No,
Why is
I'm
everyone
sorry.
hitting me today?
I'm sorry. I'm
You got a lot
sorry.
of learning to do about what you say to people and what you say about people, because you're saying that I refuse to meet with you. That is not the case. I told you exactly.
I got a lot to learn. What,
Mr.
you,
Savage,
what, say
you need
about
to
people.
not interrupt people when they're
Seriously?
talking to you too. This isn't fucking kindergarten. What I'm going to say to you right now is that I told you exactly when I would be available and exactly when I could talk to you and that I would talk to you at that time, and you said no. So, fuck yourself.
No, bullshit. You know what my office hours are. We've talked previously, and the fact that you're lazy is not my fault.
I'm lazy.
You literally could have said this
I'm
days ago.
lazy.
Yeah, your own fucking ability to want to sit here and stand on a fucking soapbox and scream at the top of your fucking lungs so everyone sees you and get all the attention is the fucking problem here.
Right.
Not the work
right.
these officers did. It's railroading these guys when it wasn't in fact their fucking fault. Their officers. You know that. I know that. You choose to be an asshole, you can be an asshole. I don't give a fuck.
I'm representing my clients. That's what I'm doing.
Well,
This isn't about
we'll
me.
see what happens when Coyote comes back. But have a good night. I have other things to attend to.
Mr. Braun, your perception of respect is really skewed because I don't think
Savage.
Detective Wolf would necessarily agree with it.
Yeah, well, Detective Wolf drew a firearm on me and led me at gunpoint out of the PD, so, you know. I don't really care what his opinion is, to be honest with you. You guys are the biggest gang in the city.
You're
we're a gang.
Do whatever the
Exactly,
hell
Mr.
you
Braun.
want to, and then you get promoted.
Really starting to sound like the clients you represent.
Well, it's true. You guys think you can do whatever the hell you want to, whenever you want to, and there's no consequences. Do you know why? Because usually there aren't. And there probably won't be here. And that's fine. But no one's going to respect you for that. No one's going to hold a parade for you for that. No one's going to like you because you go around doing whatever you please and cutting corners and doing things the wrong way. Makes me sick. Should be held to a higher standard.
So should you, Mr. Braun, but it seems you stoop to the people you represent.
Well, if you got a problem with it, then subpoena me or file a warrant or charge me with whatever you want to. You can do whatever you want to anyway.
I'm going to put this court back into session. Can everybody hear me?
Yes, Your Honor.
Yes, Your Honor.
Yes.
All right. I want to make it perfectly clear today. I will be making a ruling on this case, and it will not go to trial. I feel that everything that was said here will be redundant. There will not be any witnesses because it's all based off of case law. So it going to trial would literally be a repeat of what we heard today. The ruling I make today will set a precedent in this city for a further way for financial information to be obtained in a lawful manner. Mr. Braun, you filed your court case under federal law, which only pertains to federal agencies. You did not do your research, and you jumped the gun filing this case. You argued that a warrant itself was invalid, and that's irrelevant in the filing of this case. You filed for the Privacy Act violations, not the validity of the warrant. Fortunately for you though, Mr. Braun, I did do the research. And even though these statutes were not listed in your filing, the court still has an obligation to uphold state laws. I recommend in the future, when you do file cases, instead of reading the summary on a wiki, you do more research, and we can all learn from this in the future.
I didn't read a wiki.
This case will actually fall under a tort case, and would be considered a tort liability. Filed for punitive damages, but punitive damages in tort liability cases are for intentional behaviors. I do not believe the DA or the CID was aware of California regulations on this.
No, we didn't win.
Punitives are for high-level payouts through the gross intentional level of misbehavior, and that doesn't apply to this case. However, the court does need to set a precedent in the future handling of these types of cases. Unfortunately, sending a notification 10 days ahead while only having 20 days to work the case afterwards, since there's a 30-day statute, that's not feasible. But the court will set a precedent for a thing called U.S. Code 3409 that falls under Chapter 12, called a delayed notice. This allows time added for financial warrants before they are disclosed. A delay wasn't ordered for your case though. Therefore, the damage is already done, and it's too late to go back. We can only move forward. In the future, in any search warrant on bank records asked from this court, the court will automatically ask for a delayed disclosure of 10 days, which will immediately allow, as soon as the search is done, the person that is being searched will be notified. I feel that's the only way it would work in this city and still not come any sort of violation of the law. So the process in this city is a little different, and it's hard, and we have to make things work while still being under the law, but in a different fashion. So from this day forward, anytime a financial warrant is made, a delayed notice will be court-ordered so it can be served on the day of the warrant, which would still allow 30 days for investigation.
I don't even know what that.
The state statutes also states that all agencies on a state level hold an immunity to liability or criminal charges. That means no officers, no judges, no DA can be held liable or criminally liable under the California Financial Statute. But this does not include the state. Back to the damages. I do not believe punitive damages happened because it wasn't intentional in my review. I do believe, though, that Mr. Chang's Fourth Amendment rights were violated. And he does have a right to compensation. Luckily for you, Mr. Bryan, I am not going to give my verdict based off of what the California or federal statute says, because inside the statute, it would only award your client $100 per violation, which would mean there was only one violation, so he would only be awarded $100. Today, the court will not be rewarding Mr. Chang with $100 per statute, but will be rewarding him for a Fourth Amendment violation. The violation is completely unwarranted, disgusting, but not intentional. That being said, I will be rewarding Mr. Chang and the said other files on the previous cases that are pretty much a class action lawsuit with this case, $40,000 each.
$40,000. $40,000.
If you have any questions, feel free to come to me and ask.
That's not Pog. That's not Pog. That's not Pog. No. No, that's not Pog. That's not Pog. That's not Pog. That's a joke. That is not Pog. That is not Pog. That is not Pog.
Yeah, our profiles were a match on the internet. But what do? I'm an architect.
Not Pog at
I
all.
actually helped design the, no.
And for all the fucking work that I put into this shit, I'm sorry, but I'd not just read a wiki. All the work that I put into this shit, what does that amount to? That amounts to like, I don't know. Fucking $5 for Murphy.
All right, chat. I got some papagas in here. That's all right. So I gotta put you retards on a fucking leash because you're so fucking stupid. You can't understand common sense. All right, you ready for this? The lawsuit wasn't for the 3-day hold. The lawsuit was because his financial records wasn't disclosed. The 3-day hold is a separate lawsuit. Stop being fucking stupid. Thank you.